A lower court had previously ruled that the disqualification clause did not apply to the presidency because the president isn't an officer of the United States, one of the main points that was argued by Trump's lawyers. But the Colorado Supreme Court struck that down, writing, quote, President Trump asks us to hold that Section 3 disqualifies every other oath-breaking insurrectionist except the most powerful one, and that it bars oath breakers from virtually every office, both state and federal, except the highest one in the land. Both results are inconsistent with the plain language and history of Section 3. However, due to the extraordinary and unprecedented circumstances of this case, the judges noted that if Trump appeals, which he is certain to do, the order is stayed, basically until the U.S. Supreme Court resolves the issue. That means Trump could still appear on Colorado's primary ballot, since the state is supposed to begin printing them on January 5th, ahead of its primary on Super Tuesday, March 5th. But perhaps the most notable part of Colorado's Supreme Court decision is that it affirmed the lower court's ruling that the attack on the Capitol on January 6th was indeed an insurrection or rebellion, and that Trump engaged in it. Those are some of the key questions that the 9 justices of the Supreme Court will have to confront when this case reaches them in the days ahead, and their decision could have far-reaching consequences since similar lawsuits are currently pending in multiple states. I'm joined now by Noah Bookbinder, Executive Director of Citizens for Responsibility and Ethics in Washington, CREW, which is the organization that helped to file this lawsuit on behalf of the group of Republicans and non-affiliated voters in Colorado. Also with us is former United States Attorney Barbara McQuade. She's an MSNBC legal analyst and co-host of the amazing Sisters-in-Law podcast. Good morning to both of you. Thank you for being with us. Noah, you and I last spoke literally moments before the Colorado Supreme Court issued its decision, and you were actually quite confident that it was going to go the way it went. Since then, what are you thinking happens next? How does this move? How does this proceed now? I assume the Trump team appeals this, and then what?
So, obviously we're in a little bit of uncharted territory right now. We don't quite know what's going to happen. Donald Trump's team has indicated that they are going to appeal. I think we assume that they will in fact do that, and that they will do it soon. And if that happens, if they do appeal to the U.S. Supreme Court, then there are a couple of ways it can go from there. One is the Supreme Court may decide that they don't think this issue is ready yet for them, and they'll see what other states do. And if that happens, then actually this ruling stands, and Donald Trump won't be printed on the ballot in Colorado. There certainly seems to be some likelihood that the U.S. Supreme Court will take it up. If they do, we think it's really important that they move very quickly, both in order to have a decision while that could still affect who is on the ballot for Colorado's primary, and to give some certainty around the country so that other states and know what to do, and Americans know what the law is. We think the law is clear. We think the Colorado Supreme Court was right, but obviously it's a really important and for most people new issue, and clarity is going to be very important.
Barbara, the Colorado Supreme Court is now at least the third court in the country to weigh in and rule that January 6th was, in fact, an insurrection. This was a key point in this case. A court in New Mexico reached the same conclusion last year as these 2 Colorado courts have. How significant is that there's now this growing record of legal opinions affirming that what happened on January 6th was an insurrection? The Supreme Court ultimately, I think, is going to have to, at some point or other, address that particular question.
Yes, and I think one of the things that was important about the litigation in Colorado is that there was a trial. There was actual fact-finding on this issue. They heard testimony from police officers who were there that day, from members of Congress who were there that day, as well as experts to reach that decision. So I think that's very important for both history and for this case. There are those who are complaining that Donald Trump has been denied due process in some way. But I think they're conflating a finding of a criminal violation of insurrection. It is a crime to engage in insurrection, where you get due process rights like the right to confront your accusers, the right to testify, the right to cross-examine witnesses. But that's where one's liberty is at stake. This is a civil case. And so due process in this case is the kind of trial that we saw with fact-finding. And so I think that is what makes this solid. And when the Supreme Court reviews it, they don't have to do their own fact-finding. They can rely on the fact-finding that was done in Colorado.
This is a very interesting point that I want to explore with you a little bit, Noah. This is not only is Donald Trump's liberty not at stake, this isn't a penalty. This is meeting the needs of a qualification to run for president. It's the equivalent of saying, if you're not this tall, you can't go on this ride.
That's absolutely right. The Constitution sets up qualifications for the presidency. You got to be 35 years old. You've got to be a natural-born citizen. You can't have already served 2 terms. So, for instance, if Barack Obama were to try to run for president, a court would look at it and say he already served 2 terms and he's not eligible to serve another one. Similarly, the Constitution says you can't have sworn an oath to support the Constitution and then engaged in insurrection. Obviously, the fact-finding is a little more complicated than somebody's age or whether they served a couple of terms. That's why, as Barbara went through, the court in Colorado held this really exhaustive process where actually Donald Trump's lawyers did have the chance to cross-examine witnesses. Donald Trump put up his own witnesses, a good number of them. And, you know, there was this extensive fact-finding. But it is really important that this is separate from a criminal proceeding. So there have, since the 1860s, been 8 cases in which a court has found somebody not qualified under the 14th Amendment. And not in a single one of them were any of those people charged with or convicted of criminal insurrection, because this is not a criminal penalty. This is a separate a separate inquiry to see if somebody is qualified under the Constitution.
So, Barbara, let's just understand that a little bit more for us non-lawyers. It's not, if it were a criminal, if it affected his liberty, Donald Trump would be entitled to different things, as you said, certain due process, certain the ability to confront his accusers or whatever the case is. Because this is a qualification discussion, there was actual fact-finding, and it was a 68-page decision, and it was actually quite detailed. They went through the various ways in which they can consider what a rebellion was and how to determine Donald Trump's involvement. It was actually quite legally thorough.
Yes, that's right. And, you know, that's where fact-finding occurs in the trial court. And appellate courts are very deferential to the fact-finding that's done by a trial court. That's because the trial court is in the best position to witness the witnesses, to observe their body language, to make findings of credibility. And so we had the district court findings of engaging in insurrection. We saw the Supreme Court affirm that finding. And so any additional review of this by the U.S. Supreme Court will rely on those same facts that were found below. And so, as you say, this was not just a sort of a slapdash assumption that he engaged in insurrection. It was an analysis of the facts and the events that occurred on before and after January 6th to make this finding. And so, as Noah said, this is all about whether someone's qualified to serve on the ballot, not whether someone is going to be spend time in prison as a result of insurrection. As he said, we couldn't elect Barack Obama to another term, nor could we elect Taylor Swift, who's only 34 years old, nor could we elect Prince Harry, who is not a natural-born U.S. citizen. Are those anti-democratic? Maybe, but that's what the Constitution requires. I
can't believe you went there about Taylor Swift. That's going to, like, the backlash to that one's going to be, wow, Taylor Swift cannot be elected president this year. That's going to be, that's earth-shattering. All right, hang on for a second. I want to take a quick break, pay the bills, and